Joining me now, talk about all the developments in the case is criminal defense attorney Whitney Boan. Whitney, good to see you as always.
Good morning, Bob.
As the defense attorney, are you reticent to put your client on the stand testifying in their own defense?
I am. You know, defendants in criminal cases have a constitutional right not to take the stand when they're on trial. And so even if my client is innocent, even if I believe he or she is not guilty, I don't like putting my clients on the stand because that's just an opportunity for jurors to look at my client and think they don't like something they're saying, something about how they act comes off wrong. They could be nervous, you know, and it could seem like dishonesty, even if it's not. It's just a risky decision. And in cases that don't involve self-defense especially, it just doesn't usually make a lot of sense. If it is a self-defense case, it might be a different scenario and a different equation in that situation.
Does that then lead you to maybe learn something about what the defense is going through because they did put him up on the stand?
Yes, and I think in a case like this, you know, it's not probably a secret to prosecutors, to the state attorney's office, what Markeith Loyd's defense was going to be. I don't think that this comes out of left field for them, but certainly there are a lot of situations where as a defense attorney, I would not necessarily want to totally cue prosecutors about what I'm going to be arguing in closing arguments and my client's defense as a whole. Usually they find out as the trial goes on anyways, but there's some situations where you might want to keep that closer to your hip as a defense attorney.
And even in that short clip we showed, he was kind of agitated and animated, and jurors might not like that, especially when they hear, I shot her in self-defense. I shot her 8 times in self-defense. Yes,
and while Markeith Loyd is presumed innocent, of course, pursuant to our Constitution, sure, he is a colorful character. There's no denying that. I mean, he is someone who's got a boisterous personality. He has an appearance of his eyes being different as a result of the injuries he sustained when he was taken into custody. So certainly it is something where he has the right to testify. All defendants have the right to testify if they choose to do so in their own defense, but it's sometimes a risky decision too in terms of how that's going to be perceived by jurors. Yeah, and he also opens himself up now to cross-examination, which may happen to him today. Let's talk about the juror real quickly before I let you go. Is it hard to get kicked off of, you know, to be dismissed as a juror? Well, I know a lot of jurors wish that it was a lot easier than it is, but if you are talking about the case in any manner while you are serving as a juror, you are not doing your duty as a juror, and so you cannot remain on the jury in that situation. And it's my understanding that's essentially what happened here, and that this alternate juror had to be dismissed because of a discussion about guns with a deputy.
Absolutely. Whitney, we know you gotta run. You gotta get to court yourself, so we appreciate you taking some time for us this morning.
Thanks, Bob.